Welcome to Small Practice Support Information Session 24. In this Law Society of Ireland recording, Aidan Leonard and Aisling O'Neill talk to Justin Purcell about the PII Special Purpose Fund.
It's a great pleasure to welcome you all to a Small Practice Information Session, I can't believe, 24. And we're here with Aisling O'Neill and Aidan Leonard from DWF Claims Service. And we're going to be talking today about frequently asked questions on the Public Indemnity Insurance Special Purpose Fund, which was set up in association with the Law Society. So Aidan is a special purpose fund manager and head of CMA Ireland. And Aisling O'Neill is a ACII chartered insurance practitioner and working alongside as a senior claims adjuster with Aidan. So you're very welcome to the show today. I'm going to pass over my screen to you, Aidan. I know you're in the dark there slightly, but at the end of the session, I guarantee you all we're going to be enlightened. So we're looking forward to it. So feel free to share your screen there. So just if anybody wants to ask questions, we're taking them on the chat. All questions will be anonymized, so we won't be associating any names with it. So we'd really like as we move forward that anybody would ask questions. So Aidan, you're going to give a brief presentation with Aisling there now, and then we'll be taking questions towards the end. So
no problem.
Thank you, Aidan.
You see the screen at the moment? Everything okay?
Yeah, everything perfect. Yeah.
Okay. Okay. Now. Okay. Thank you, Justin, and thank you everybody for joining us this afternoon. We will run through, I suppose, what the key elements of the Special Purpose Fund is. And we'll do it over the next 20 minutes or 25 minutes or so, and we'll open up the floor for questions. The key elements of what we'll cover today is what is the Special Purpose Fund, who operates it, the why it was introduced, and we'll go through the various eligibility criteria for runoff and assigned risk pool. We'll touch on a very important facet of it, which is the succeeding practice rule, the applications for ARP, the applications for runoff. All these terms will become evident over the course of it, and why the cover is actually different to the open market cover, and the importance of the compliant and non-compliant firms, the obligations and the implications, and why that plays a role. And just to touch on quickly then the changes to the indemnity regulations associated with the Special Purpose Fund for next year. So I suppose, what is the Special Purpose Fund? The most important facet of all of this is to understand why it was set up. This is an integral piece of the solicitor's indemnity market. And what it does is it's a fund that was set up by regulation in 2011 and 2012 with the Law Society and the market. And essentially what it does is it allows for firms to make a choice realistically at a very important part of their careers, in terms of whether they either cease to proceed to practice, or alternatively they cannot get cover on the open market. And the reason the ROF and the ARP are a fundamental part of the umbrella term, which is entitled a Special Purpose Fund, is quite simply to allow firms make that choice, because it's a very difficult choice. And for numerous different reasons, firms close or cease to practice, or alternatively firms cannot get cover on the open market. So I suppose the Law Society in tandem with the market and the solicitors indemnity market have come up with this very unique vehicle essentially to allow the market to proceed and to act in a very equitable and a very fair manner. So as I say, the Special Purpose Fund is the umbrella term. It's made up of the ROF, which is the runoff fund, and the runoff fund provides runoff cover for all eligible ceased firms. And there's various bits and pieces allowed. Firms must have ceased practice after the 1st of December 2011. You must meet criteria, obviously, in line with everything else. And the indemnity period runs from almost in tandem with the normal indemnity year. I suppose the assigned risk pool is something quite different. And essentially what it is, it's an insurer of last resort. And again, you must meet criteria. There's a premium calculable on that. And the firm can only be in the ARP for 12 months and must go back out into the open market the following year, or alternatively cease to practice. So I suppose you can understand in many respects why the ROF and the ARP are quite aligned, because those decisions either to cease or to carry on for one more year are very important decisions and are mainly done at more or less at the same time. So who operated? We operate in DWF Claims. I'm the SPF manager, and we've been operating it since 2014. And we are mandated by the Law Society of Ireland, but we act as agent of the participating insurers for the market. So essentially, the Law Society has no liability for the Special Purpose Fund, but in fact has managed to set it up in such a way that allows for the smooth operation of the market in Ireland. And again, it's very unique and very different to our UK and Wales counterparts. And it's very fundamental reason as to why the Irish indemnity market is quite successful in that regard. So why was it introduced? And I suppose essentially the Special Purpose Fund was introduced to assist firms intending to cease practice. It was making retiring more affordable for solicitors, obviously to improve the public protection, which is paramount. It was also introduced to prevent abuse of the system, for example, a succeeding practice, which we'll touch on later in the slides. And essentially, it was an incentive for solicitors to do so in an orderly manner. And there's incentives built in to continue that to be the way. Now, you must meet the criteria, the eligibility criteria. And if you intend to cease practice, obviously you enter the runoff fund. But in order to do so, you must have had qualifying insurer in the market. You must hold an insurance with a participating insurer immediately becoming into the ROF. And you must not be a succeeding practice. And I'm laboring the point on that, but it's a very, very important piece of this. The ARP is slightly different. And essentially, a firm applying for ARP does not hold qualifying insurance at the date of the application. There's a payment of a premium. And again, that's built into the regulations. And we offer the premium. We're duty bound and mandated to do that. But essentially, we are the insurer of last resort. Most people applying for ARP cover do so because they can't get cover on the open market for a number of different reasons. And that's why that is a last attempt to allow firms to continue to operate. So again, it's a very fair, a very equitable system to exist. So a firm essentially can go into ROF if they want to cease, or go into ARP if they want to continue. But there is criteria around both of those for obvious reasons. The succeeding practice rule is something I mentioned a couple of minutes ago. And essentially, the runoff fund wants to rule out a situation where a firm simply closes its doors and opens up under a different guise the following week, the following day, or the following year. So essentially, it's an equitable system again, but we do not offer runoff cover to anybody who we deem, or any firm we deem to be a succeeding practice. And there's various criteria set out. And again, we work with firms who are thinking about closing their doors, or thinking about amalgamating, or being bought over, or whatever the case, or even purchasing, as to what this would mean for their runoff or their insurance. So again, any questions around this succeeding practice is we're very open to having them, because it's a very unique situation. But what is a succeeding practice? And I suppose there's 6 elements there which we can read down through. It is held out as being a successor practice, or part thereof. Half or more of the partners of the practice are identical to the partners of the ceased firm. It's conducted by a sole practitioner who was a sole practitioner in the preceding firm. It's conducted by a sole prac who is one of the principals conducting the ceased firm, or where the sole practitioner who conducted the ceased firm is a partner in the practice and no other firm has been held out to be. And finally, the practice which has assumed the liabilities of the preceding practice. And I suppose those are the criteria that we look towards in order to deem whether or not a firm is a succeeding practice. And if so, they're not eligible to enter into the runoff fund. So in terms of applications to the assigned risk pool, so if for argument's sake this year you cannot get cover on the open market, you can obviously apply for ARP. And you must notify the SPF manager prior to the 1st of December, obviously. And you must furnish us with a copy of your most recent proposal form. and which really sets out the income of the last 3 years. You will furnish a copy of the schedule with your incumbent and confirmation that all claims and circumstances that may give rise to a claim have been notified. And we look for a claims experience. So I suppose in many respects, applying for ARP cover is quite similar to applying for a cover in the open market, albeit you're not going through a broker, you're coming directly to us. So we operate the very same model for continuity purposes. So what happens, what are your obligations if you want to come in to the ROF, and what your obligations are post ROF? So if you intend to cease practice, you must provide us with a written notification within 60 days and to the contact number and address above. You provide a copy of your last policy document and your proposal form, and you fully cooperate with the queries that we raise. An important part of this is it's a very much a dual obligation that you must adhere to the close of practice guidelines, and those are fundamental. And obviously, you must notify the circumstances and claims to your incumbent insurers prior to entry. But anybody ceasing to practice, we would want them to engage with us at the earliest possible stage to talk through that, to talk through the process, to make sure that you do everything right by what you want to do and that you're covered going forward. Because this is a very unique and very generous scheme that operates, and it incentivizes you to do it in the right manner and for the right reasons. I suppose after you come into the runoff fund, we're just touching that now. If, for argument's sake, God forbid, you got a claim against your previous firm or your ceased firm, you must obviously promptly notify any claims. You must fully cooperate as you would normally, and give us any information if there's a material change in your circumstance. But it also your contact details. You know, somebody ceased in practice, you will receive a type of cover, obviously for the period of which you're in the runoff fund, and obviously we need your contact addresses if you're intending to travel or wherever. Now, a major part of the decision-making process for a firm making decision to either to cease or maybe carrying on for one more year is the cover that's basically in force. And this is something that we can work with you with your options down the line. If you're intending to cease and you go into runoff, it's infinite in duration. There's no premium. There's cover for financial institutions for those who are compliant. Again, touching that later in the slides. There's an aggregate limit of 1.5 million. There's not in each and every claim, and that's very different to the open market as it is. You carry in the same deductible or excess that you held in the year prior. And I suppose if you intend to operate for one last year, and again can't get cover, again you're only limited for 1 year to be allowed in the ARP. There is prohibition on startup firms, so you're not allowed to be a startup and enter into ARP. Obviously, the premium is calculated in accordance with the regulations. But one of the key areas that we make it very clear to practitioners and to firms if they're going into ARP, the claims by financial institutions are excluded. And this can be very difficult for firms who have a banking or banking exposure or financial institution exposure. And obviously with their contracts and things like that, anyone looking for your proof of cover, if they see ARP cover, they will straight away know that you do not have cover for financial institutions. And again, that can be a barrier to business. And we want to make sure that you're fully aware of that and what implications that has. So we operate, again, under a system of trying to help you through the process and what's best for you, and obviously in your firm and your business. Earlier in the slides, I touched on compliant and non-compliant for runoff. So what we've established over the course of a number of years is that firms who come into runoff and have done so in a manner which was probably not the reason the runoff fund was set up, there was issues regarding their compliance in terms of claims, notifications, and so on and so forth. And over the past number of years, the regulations changed to allow for a situation where if you're compliant, you have nothing to worry about. You've done it for the right reasons. You're trying to help out. You're in the runoff fund. You've free cover. You've got all the ancillary bits around that. But unfortunately, Section 9 of the regulations have come into effect in 17, and you have an ongoing duty to cooperate. And if you don't cooperate, we can designate you non-compliant. And essentially what that actually means that you've reduced cover. So it makes no sense to go into runoff and be non-compliant. This is a very important part of it, to make sure that you continue to be compliant throughout the duration of runoff cover, even though you've ceased practice, because again, it will have an effect on the cover you're provided. So in a situation where you're non-compliant, for example, a financial institution claim would not be covered. And that would go against you and your estate and or the partners of the ceased firm. So again, we would obviously want you to come in for the right reasons, but also to cooperate throughout the process. There's a couple of key amendments coming down the track for the new year, and essentially runoff cover was going to be infinite. It's now going to be amended for 6 years. So anyone may be thinking maybe next year coming in, and maybe thinking ahead what they're going to do with the firm. If you apply next year, for example, you won't get infinite runoff cover. You'll get 6 years cover, and that realistically covers the 99% of any potential claims arising due to statute issues anyway. We will obviously, as runoff, the SPF manager will carry out risk management audits for new entrants where appropriate. So where you come into the fund or potentially want to come into the fund, the runoff, the firm and the SPF manager will work together regarding that in a more collaborative way, which could mean an audit of why and on the files and so on and so forth. Furthermore, and I go back to the non-compliant aspect, there will be a premium where at the moment you would not be charged a premium to enter into the runoff fund. But if you're non-compliant, not only are you going to get reduced cover, but you'll be level with a premium for the cover you actually do have. So again, I mean, it's very, very important that you continue to be compliant and compliant throughout. There's an amendment of the definition of the succeeding practice. And previously under paragraph 2 of the definition, half or more of the principles of the new firm are required to be identical to that of the preceding partnership for the firm to be considered succeeding practice. This has now been broadened so that only 2 or more principles are required to be identical for the succeeding practice rule to trigger. So again, if you are selling your firm or you're going to do something different with your life in terms of what you want to do in your firm and your practice and yourself, look towards whether or not you would be deemed a succeeding practice, or because that is where we will have to reduce the cover or not cover you at all. And obviously there is a new firm regarding insolvency of participating insurers, which doesn't affect you as a market, but that's an amendment coming into the regulations from next year. And I suppose the key takeaways from all of this is as follows. I suppose making a decision to cease practice is very serious for everybody. And some people do it for a number of different reasons. But the important thing is you get the application in on time, to be compliant, to do it in the right way, to cooperate and collaborate with us. And if you do that, you get free runoff cover for 6 years. You carry in your deductible. If you decide to make the decision, you know what, I've 1 more year left, or I can't get cover on the open market, we do operate at a assigned risk pool cover premium, and that is a fallback provision for firms who simply really want to trade and for whatever reason cannot get cover, and that can happen. And we pass no judgments around that. We're here to help. We're here to serve. We're here to do right by you in terms of what you want to do with your firm. So I suppose those are the 2 main takeaways from this today. And any queries you would have in relation to what you want to do with your firm, please contact us and talk through those in a very private and confidential manner. Because as I said, we acknowledge the fact that this is a very serious and very private matter for you and for your firm. So we're here to help in many ways. That concludes the overview of the Special Purpose Fund. And if we want to open the floor, Justin, in terms of questions or anything like that, happy to take them. Again, acknowledging the fact that maybe people don't want to go on the chat because of the fact that this is something they want to take up directly with us. By all means, we're here to help, and the contact details are below. So,
sure. And just to reiterate that, Aidan, that any questions are asked on the chat, like it is a sensitive subject matter, and maybe people feel a little bit that they don't want to get associated with the question or whatever, but we're not going to mention any names. So if anyone has a particular question, sure, we'd be happy to take it. And obviously Aidan and Aisling are available for one-to-one confidential call if they had issues that they wanted to discuss with them on a more private basis. So thank you very much for the presentation. So, I mean, just started off, like, what is the, at a very basic level, what's the relationship between DWF Claims and the Law Society? Like, how has it come about? And
yeah, an invitation to tender came out many years ago in respect of managing the special purpose fund. So the Law Society provided the framework for this, and the solicitors participate, insurers obviously fund it. So I suppose the Law Society obviously draft the regulations and in that way, but ultimately we're an agent on behalf of the insurers, because they ultimately pay for this. So the Law Society provide the framework, and we obviously administer that in accordance with the regulations that are set out. We're custodians to the fund to make sure that it's that any people entering the fund do so in an orderly manner, or entering the ARP in an orderly manner. We charge them the premium. If there's claims emanating from those firms, in either or both, we administer those claims as we would in any claims department. So our role is dual in many ways. We operate as underwriter and claims. So we're essentially quite a unique facility that, as I say, that operates, but it's integral to the market in terms of its operation, because it allows an orderly wind down, and it allows public protection for firms who are ceasing. So anyone who is a client of the firm obviously would have standing in terms of any negligence that might have arisen in that firm. So ultimately, the runoff fund and the runoff policy in that regard is very, very safe, and it's very, very good. But the market ultimately pay for that if the claim is X value and there was negligence that's against the firm. We would obviously pay those claims in accordance with best practice and procedures. So that's kind of an overview of the relationship we have. So the Law Society sets the framework, sets the regulations, and we administer that. So we kind of ultimately sit in the middle and make sure that we're the conduit between both the market and the Law Society. But ultimately, we act as agent on behalf of the insurers, because ultimately they pay for anything that's emanating from the fund and or the ARP.
And so, if I want to apply to either of these two schemes, is it an application form? Is it the common proposal form that I should be using, or do you have your own application form?
No, it's
separate.
It's essentially, if it's runoff, just in terms of that, it's essentially adhere to the close of practice guidelines. You notify us of your intention, and then we seek the information from that point. And ultimately, what we seek is a copy of your documentation for the year that you sought insurance previously. So there's no application form as such. You've done the work if you're a practitioner already. All you have to do is forward us your current schedule, your current proposal form for runoff. If you go into ARP, you will have obviously tried to get cover on the open market, because we're an insurer of last resort. So we essentially take the document that you've essentially sent into the market, and which will be the general common proposal form that's there. So again, we don't have a separate, we want to make it kind of easier for practitioners and firms to apply, so not to make it overly onerous in terms of admin. So essentially, if you're applying for either or, you just simply write to us, and we will obviously set out precisely what we need, which you probably have anyway. And it's very rare that we would ever come across a situation where you wouldn't have the information we need to determine the criteria and the eligibility of that.
Okay. And when you say write to us, is that write to you personally, or?
Yes, we have. So we have it's the SPF@dwfclaims.com, and either or Aisling and I, and so we have a general mailbox obviously for that in email. We're based in the IFSC in 5 George's Dock. The information is up on the Law Society of Ireland website under the PII, so you can find us there anyway, and the contact details. But certainly we're here today. Anybody looking in today, or maybe later online on YouTube or wherever, we have our information straight there, our direct email address, so we're happy to take that.
So let's say I was a retiring solicitor. How should I approach this issue? Like, if I'm going to pass it off to somebody else or sell it on to somebody else, are there issues that I need to consider? Or if I just want to close the business itself, what would I need to do?
Well, if you want to close the business full stop, and this is the decision, again, practitioners we've found over many years have numerous reasons to close. So if you simply just want to close and you're retiring and you've done your due, you want to go in, you want to go and play golf for the rest of your days or wherever, or travel, whatever the case may be, you simply write to us, as we said, to say that's your intention to cease, and this is when we're going to cease. And then we work with that, and we would say, right, okay, we will provide you, and we will bring you through the process, and all things being equal, we will provide you with runoff cover there, like without any hesitation. If for argument's sake you're weighing up your options, you're thinking about selling your firm, you're thinking about there's interest in your firm for whatever reason, or you might want to leave a legacy, that's where those conversations with us have to be had around the succeeding practice. Because essentially, if you want to sell your firm, the firm buying your firm ultimately could be deemed a succeeding practice. So the firm of Justin Purcell and Co. would not be eligible for runoff in that situation, because if I was buying your firm, I would have assumed your liabilities de facto in reality. So therefore, my insurance would ultimately have to be notified to cover your firm coming on board. And that's a very straightforward example. So there's numerous aspects to it. So essentially, the runoff fund essentially is designed for complete ceasing of all activity for that firm. If there's any suggestion or otherwise, that's when we have to investigate whether there is a succeeding practice. Because the runoff fund is not designed to pick up firms just basically closing and opening up under a different guise, or there is a connection, or that's not what it's designed to do. And that's a very fair and equitable system, because again, in order to do so, to allow firms in would allow for abuse of that. And I'm not saying the practitioners would do that. It could be done inadvertently. So we educate people coming in as to if they're eligible and what their best options are at that particular point in time. So talk to us about what's going on, and we can provide a support network around that to give you the best outcome for you as a practitioner and or a firm.
So just at the opposite end of the spectrum, and I know you've kind of intimated that you don't kind of cover this, but if you're starting a new practice and you're trying to finding it very difficult or impossible to get PI cover, what do you suggest that their options are? Because this fund doesn't apply to that, does it?
No, it doesn't. And I think, in fairness to the Law Society, they have really good supports around that. And equally, we provide the support through the SPF to close down. The Law Society have a very support network there for firms and advice to start up. So I would suggest liaising with the Law Society around that. But I suppose from a very practical perspective, knowing the market, I mean, again, there is a list of brokers on the Law Society of Ireland website, and any firm starting up are best served by looking at that. And it's a very, very unique market. And what we found is that the broker network are very helpful around trying to arrange cover for a startup firm. So in terms of that, if I was maybe thinking today of starting up and I was looking in here, I would say, right, okay, I would check the Law Society of Ireland website, look at the support network there to start up the Start Work program, and then ultimately go online. And there's a list of brokers there who are completely skilled in arranging cover for a defined market, because obviously that's a very defined market as to who picks those individuals up or those firms up. So again, that's what I would recommend in that situation. Unfortunately, we can't help around that. We're here for firms at the end of their days almost, in many ways, and to support them through that process and make sure that they're comfortable and secure as they go into the abyss or whatever they want to do.
And maybe I could reference a previous information session that was with Terry Dunn, who's a broker for First Ireland Insurance. So that's up on our website also, and maybe that person could refer to that so that he talks through the different options available to people.
Absolutely.
So I know we're kind of coming to the end of our time allotted for this. So if anyone has any final questions, we're happy to take them. Aidan, if you wouldn't mind just rolling on your slide there one more. I just talk about the next week's session. We're having James Kiernan from Chambers of Commerce Ireland, who's going to come in and just talk about the opportunities and benefits of being involved with the local Chambers of Commerce from networking and business development opportunities regionally throughout Ireland. And on the 2nd of December, we will have David Rowe talking about buying or selling a small legal practice. So all of our previous sessions are available on the Law Society support webinars website. So a big thanks to Aidan and Aisling.
Just on the buying and selling a legal practice, I mean, that's very much for anyone at the moment to listen to David, that would be really, really important, just to make the point to link in with what we're doing, because obviously that feeds into the succeeding practice element of it and what implications that has for runoff. So that's a really, really key area. I would just make the point. So just to make that point to you, and
to make sure that the practices are adhering to the succeeding.
Indeed, yeah.
Very good. So do you have any final comments for us, Aidan, in closing?
No, thank you for the opportunity. And yeah, any questions, you can, obviously you have our details.
Yeah, do you want to just flick up your details there for a second? So if anyone wants to make direct contact either through myself or through yourselves, I can refer them on. But thanks very much for the time today. I know you put a lot of effort into thinking it through. And so thank you very much. Thank you to both Aisling and Aidan from DWF Claims. So next week we're here with James Kieran from the local chambers of commerce. Have a good week, and slán.